workers or employers and employees. It was more like capital and labor. So the relationship between the capital and labor was more personal in nature. That was the situation. And the Shukla Yajurveda Samhita as well as Kautilya's Arthasastra. If you go through these materials, you can see some mentioning about the existence of union even in those days. Right? The Shukla Yajurveda Samhita says, if men are united, nobody can deter them. That is the caption they have given under this material. Right? But of course, during the Mughal period, when was the Mughal period? Mughal period, which century? 16th century. There was no evidence for existence of any union in that particular period. And of course, the modern IR, whatever we call it as IR today, it has its roots in the 19th century, in fact, when India was under the control of the British rule. Particularly, you can divide it into three phases. Starting from the later part of the 19th century till the end of First World War, then that is 1918. And from 1918 to till the time of independence, it is the second phase, and the post-independence period, that is the third phase. And in those days, in fact, the industrial relation was not good. Only the management and workers were considered as stakeholders in running an industry. There was no intervention by the government or any other party for that matter. Even there were not so many unions at that time, particularly in 19th century. Right? Any dispute was resolved only between these two parties. Right? There were no clear norms. There was a huge labor unrest. Even there were violent situations. That is the situation during the first phase, which I said. And in 1919, the ILO was formed, International Labour Organization. And formation of International Labour Organization influenced introduction of lot of labour legislations in India. And in 1920, the All India Trade Union Congress was formed. So union activities started specifically from that time onwards. And this labor unrest and the bad industry relation that continued in the second phase also. In the second phase, in fact, between 1929 and 1931, the Royal Commission on Labour, they made a survey and they came up with some of the findings where they said it is absolutely essential to regulate the working conditions of the employees. In those days, in fact, employees were asked to work even for 14 hours or 16 hours a day. That was the situation. There was no regulation at all. Right? And salaries were not paid regularly. This month you will get the salary. Next month you are not sure you will be getting it or not. That will take maybe 2-3 months. There was not no regulation, in fact. And there were no social security measures. These were all the observations of the Royal Commission on Labour, and you can see maybe even now based on these recommendations and maybe based on the experience during the first phase, lot of labour legislations were introduced at that time. In 1923, the Workman's Compensation Act was enacted, right, which is now renamed as Employees Compensation Act very recently. In 1926, it is the Trade Unions Act, right, which provides for the registration of the trade union. And in 1929, it was the Trade Disputes Act. Later, it was repealed. And in 1947, it was made as the Industrial Dispute Act. Right? And in 1936, it was the Payment of Wages Act. The very purpose of introduction of this Payment of Wages Act is to regulate the payment of wages. You can, even today, you can make the salary payment to your employees every day or once in 2 days, once in 3 days, once in a week, once in a fortnight, once in 3 weeks, once in a month, it is okay. But it should not go beyond 1 month. Your wage period, any industry, whatever be the size of the industry, company, organization, establishment, whatever it is, the wage period shall not go beyond 1 month. And in case in your establishment, if you are engaging less than 1,000 workers, then you have to pay the salary within 7 days after the end of the wage period. If it is 1,000 or more, then it is less than 10 days. You have to make the salary payment. That is the rule even today. And in those days, in fact, deductions from the salaries were made at the sweet will of the employers. No opportunity will be given to the other parties, that is the working class, to explain his case. So those things were also taken care of by the introduction of this Payment of Wages Act. Very specifically, the Section 7 of this Act speaks about the deductions. What are all the activities for which the employer can make a deduction? What are all, which alone will be considered as the authorized deductions, right? Whatever is outside the purview of what is mentioned under the Section 7 of the Payment of Wages Act, it is considered as illegal. It is not valid, right? So somehow those regulations were started by introduction of this Payment of Wages Act. Then in the third phase, what was emphasized during the third phase was the introduction of tripartite settlement, maybe apart from these two stakeholders, employers and employees, the intervention by the government in the industry relations front, that was emphasized. And there was a tripartite conference conducted in 1942 under the leadership of Dr. B.R. Ambedkar. And subsequently, you may be aware now, in 1946, the Standing Orders Act was framed. In 1947, it is the Industrial Disputes Act. And in 1948, the Factories Act, the ESI Act, the Minimum Wages Act. All these legislations were framed. So in fact, the very purpose of all these legislations is the government is intervening into the affairs of the industries through these legislations. So it is not isolated, right? So industry relations are brought in by way of enforcing these legislations. So complying with the provisions of these labor legislations assumes importance. Right. Now you may be aware again, ESI is considered as one of the best social welfare legislations available in India, along with the PF, Employees Provident Fund and Miscellaneous Provisions Act, which was introduced in 1952. And subsequently in 1965 it was the Payment of Bonus Act, in 1970 it was the Contract Labor Act, in 1971 it is the Payment of Gratuity Act, right? So, for any establishment, be it an establishment covered under the Shops and Establishments Act or covered under the Factories Act, and whatever be the size of the establishment, definitely 15 to 20 such labor legislations will be applicable. Interestingly, labor is a subject which falls under the concurrent list of the Indian Constitution, which means both central government as well as various state governments will have powers to enact laws. Right, if you take the Shops and Establishments Act, it is a state legislation applicable only in Tamil Nadu. The name itself, the Tamil Nadu Shops and Establishments Act. If you take Labour Welfare Fund, it's a state legislation, Tamil Nadu Labour Welfare Fund Act. This act may be there in other states or may not be there. They may have their own legislation or not. Whereas there are certain legislations which were introduced by the central government, which will be applicable for all industries across India, which is Industrial Disputes Act, the Factories Act, PF, ESI, minimum wages, payment of wages, payment of bonus, payment of gratuity, all these are central legislations. That is another interesting part, but the procedural part will be differing because each state can have their own rules, that is the procedures to follow under these legislations. Though the legislation is common across India, the procedure may vary. That is the crux. So that is how the labor laws emerged, and the very purpose of introduction of these labor laws is to bring in good industry relation and ultimately to bring up more industries and thus develop the economy of the country. That is the greater purpose. And PM to HRM, whether it is personal management or human resources management. Earlier we were calling this department as personal department and whoever is heading it as a personal manager. Now it is human resources department and HR manager. What is the difference? Honestly, there is no difference. Whatever activities, responsibilities they had as personal managers, the same responsibilities they still have as HR manager. Right? Only thing is the approach is different now. What is the point? Respect for employees. Earlier they were called as labor only, and the personal management would suggest that personal management considered labor as a commodity which can be bought. It is replaceable. It is expendable. Right? But the human resources management sees it as an asset. It looks at the human side of the same person. Right? And this particular approach nurtures the human resources. When you say person, again personal management, the word itself suggests it's a person, mere person. But the person is seen as a resource person. He is competent, he has capacity, he can be developed, he can be nurtured. Right? So the individual's goal will be met along with the goals of the department or the organization or even the society at large. That is how HRM sees. But that was missing in the earlier days. But of course, this is again a history. Nothing wrong in it, in fact, because this depends upon how the business was on those days. As I said, it was a very, very violent situation, right? And bringing in discipline inside the industry, that was the foremost activity for those personal managers. They were even called as police. Even today in some of the industries, the other departments, whether it is production, research, marketing, accounts, whatever it is, they consider personal department or HR department as a policing department. Right? The basis is, in those days, in fact, bringing in discipline inside the factory, industry or the company, it itself was a greater job. So these personnel department, people in the personnel department would look for people who are committing some misconducts. They will catch hold of them, conduct inquiry, give them punishment. So that was their foremost activity, along with maybe other activities also. Then later part, because of again the societal changes, whoever is providing more welfare measures, even introduction of welfare officer, post of welfare officer happened at that time only. Whoever was holding the position as a welfare officer, he was considered to be a powerful person at that time. Right? Extending welfare measures apart from what is given in the various statutes available in the country. Those companies were considered as good companies, those employers were considered as good employers, and the personnel manager was focusing more on extending the welfare measures. He was in fact acting as a welfare officer. That was the situation for some time. Later, it is the administration part. Even today, some of the companies call this department as personnel administration department. Right? Maybe some sort of bringing in, streamlining the activities or bringing in some sort of set of policies. Right? Stabilizing. Mere administration, bringing in the personal administration for, introducing personal file for each and every individual, even if there are 10,000 employees in a company, in an industry. So that administration, the focus of the personal managers were on the administration side. And only in 1970s, the word HR was coined. In fact, in America, their personal management, one of their associations were called as Society for Human Resources Development. It happened in 1970, in fact. Then subsequently, in all the other countries, people started using this term, particularly in India, right from 1990, with the introduction of liberalized economic policy somewhere in 92 or 93. This term was, companies started using this term widely, and then many companies now use the term HR, right? But the basis is there will be some humaneness in the approach of the HR manager now. Earlier that was missing. Of course, that was the business requirement. So this is how the role of personal managers changed. So whatever the the HR manager does now, that should be for the benefit of the individual workers working in that particular industry, for the benefit of the department or the function, for the benefit of the organization, and that should be for the benefit of the society at large. Every policy should aim at that. That is how they are seeing it now. And maybe if you take this collective bargaining contracts, labor management, it was purely based on the collective bargaining. It is a bargaining means it's a settlement agreement between the trade union representing the majority of workers as well as the management. Right? So whatever terms they have agreed upon, they will just carry it out. But now it is individual contracts. Solid example is earlier if there are clerks in an industry, all these clerks will be getting same salary. Right? It is purely based on the collective agreement. Right? But today, salary of one person, it is now treated as confidential. It is not known to the other person who is sitting by his side. So it is governed by individual contracts, that is individual appointment orders. And it is treated as a confidential matter as far as companies are concerned. Right? They may be holding the same position, but yet they may have different competencies. So it is purely performance based. Whether it is legally correct or not, that is a different issue. Right? That is manageable, that's it. Right? Okay, I'm just giving you the example. So earlier also appointment orders were issued, but it contained common terms for many of these people, but now it is individual to individual. The contract and terms and conditions will vary. So that was the personal management, and this is the human resource management. Right? The fixation of salary was rule based, agreement based. This is performance based, requirement based. Right? Activities are same, but the dimension, the approach, that is changed. Otherwise, there is no difference. Right? They are not seeing people as mere persons, but they are seeing them as resourceful persons, capable persons. So, nature of HR functions. I have not listed down all the functions of the HR department. Some of the main functions. Recruitment, I have mentioned as continuous. Now it is continuous. Attrition is very, very high, almost in all the industries. Day in, day out, there will be some process will be going on in the HR department for making recruitment. In some of the companies, they have a separate department for recruitment. It is parted from HR department. There are managers appointed specifically for recruitment itself. And in those days, in fact, recruitment was done by the company itself. It was in-house. But now it is outsourced. A lot of recruitment agencies are there. Consulting companies, right? So maybe you have to provide them with the profile of the people which you like to hire. So maybe they will be identifying the people and sending a group of people to you for interviewing, then you will finalize. A lot of recruiting companies are there. So this activity was earlier fully taken care of by the companies as in-house activity. Now it is outsourced. Same is the case with training and development also. Training, of course, it cannot be always done by the HR manager or the HR department as in-house process. It is not possible. He can only facilitate, right? So that is also outsourced. And performance management, remuneration, reward, you have to frame a policy, right? Then that policy will be followed in letter and spirit. You can review the policy maybe once in 3 years or 2 years, whatever you decide. It is purely internal, right? So once the policy is done, then you have to just ensure that it is properly implemented in all the departments, wherever you are working, all the departments in that company, you have to ensure that the policy is properly implemented, right? And the statutory compliance IR, that is the crux of our discussion. It was maybe till 15 years back, it was taken care of by them only internally, but people have now started outsourcing this activity also. Again, the reason being, subsequent to this introduction of LPG particularly, and coming up of a lot of B schools, their focus is more on developing the competency, commitment, bringing in culture in a company. Most of the people who are coming out of these B schools, they are not well versed in the provisions of the labor laws, right? For some reasons or the other. Their focus is more on the so-called core HR activity, right? So that is the reason when these people take up employment as HR managers, they try to outsource this activity, the compliance activity. And there is another kind of people whom they are aware of the provisions of the labor legislations, yet they do not want to take it up because they have to deal with the inspector of factories, they have to deal with the labor department, they have to deal with the ESI authorities, they have to deal with the PF authorities. Their approach will be totally different, government people, and whatever happens between them, and they have to convince the management also. Management's approach will be totally different, right? So even though the people are aware of the activities, statutory compliance activities to be carried out in their companies, they tend to outsource it, right? Earlier there were small players just to remit the ESI contributions alone. There will be one person for a particular location. He will be taking care of remittance of ESI, PF alone, or labor welfare fund alone. Every month he will go pick up the papers, do the remittance, and he will give it to them, and maybe they will pay some 500 rupees or 100 rupees. That's it. So he will have maybe 10 companies, even shops. That is how it was. But now people are aware of the statutory activities to be carried out, but they tend to outsource this activity also now. So what are all the compliance activities? So maybe I will harp around this particular slide for quite some time, because this is the practical part. When I say service conditions, it is the working hours, or the rest interval to be given, or the number of days of leave to be given to an employee, or the number of days of holidays, weekly holidays or national holidays or festival holidays. All these will be considered as service conditions. If maybe for our discussion, we'll assume factory as for example, we will have factory as an establishment. right? In case of a factory, you can ask a person to work for a maximum of 9 hours in a day. You can have more than one shift, but you cannot ask one worker to work for more than 9 hours in a day. And the shift should be so arranged that he should not be allowed or required to work for more than 5 hours at a stretch. Suppose if you have a shift timing from 8 to 4, which means 8 hours, right? So from 8 to 1 he can work, then you have to give at least half an hour break. Then 3.5 hours. So total working hours will be 7.5, half an hour rest interval, total shift timing will be 8 hours. Instead of 8 hours, you can have it as 9 hours, not an issue. Unless and otherwise you are aware of this particular provision from the respective legislation, that is the Factories Act. When you take up the position as a HR manager, even if there is a deviation, you will not be able to find it out, right? And there shall not be overlapping of shifts, right? So maybe 24 hours in a day, you can have normally a maximum of 3 shifts, 8 hours each. If you give half an hour break, then it is 7.5 hours only, working hours, essence, right? But again, if you want to have overlapping shift, if you want to increase the working hours from 7.5 to 8 or 8 to 8.5, you can do that, but you may have to apply for it specifically, get an exemption from the authority concerned, that is the inspector of factories. Only then you will be able to do that. Right? Likewise, if you are in a commercial establishment, then the Shops and Establishments Act will be the governing legislation. What is the working hours given under that act? And what is the at a stretch maximum working hours can go up to? All those things you must be aware. Basic thing. Right? Weekly holidays, whether it is 1 day or 1.5 days or 2 days, all those things. Again, state to state, this could differ. If it is a commercial establishment. If it is a factory, then it is a central legislation, so it is common across India. You may be sitting in a corporate office. You may have operations in more than one state. But state to state, these provisions will vary. So you may have to have a pakka checklist. Right? So these service conditions will normally be governed by these regulatory laws, like the Factories Act in case of a factory, Shops and Establishments Act in case of commercial establishments or even shops, and restaurants. All those will be included in that legislation. Or even plantation. There's a separate act called Plantation Labor Act. For Mines Act is there. Apart from these regulatory legislations, there is one other legislation called the Industrial Employment Standing Orders Act. The very purpose of that act is to define the service conditions. Right? Suppose if you have more than 100 workers in your industrial establishment, then that act will become applicable. Then you have to draft these standing orders for your industry. You have to get it certified by the certifying officer. Normally, the labor commissioner will be the certifying officer. Then that will become a law for your company. But you have to ensure that the provisions in that and the provisions of the regulatory legislations. So doing registration and licensing, the next point. So if it is a factory again, you have to register it under the Factories Act and you have to get the factory license. Otherwise, you cannot run a factory. Before you commence your manufacturing process, as defined under the said legislation, that is the Factories Act, you have to get your factory registered and you have to possess a factory license, without which you cannot, you are not supposed to carry out the manufacturing process, even for the trial production. Right? And in case of a factory, once you finalize the place for constructing the factory, before you start construction, you have to make an application to the inspector of factories with the set of plans, get his approval, only then you can start construction itself for a factory. besides getting the approval from the other local bodies, whether it is corporation, municipality, whatever it is. That is different. Simultaneously, this should also happen. So even if it is a factory, before even you start construction, you have to get the approval. Then before you start the actual production or manufacturing process, you have to get the license. This is the basic thing before you start the factory. Right, you have done that. In case, if you have more than 20 workers, right, some of the legislations will become applicable to your factory. Suppose if you have more than 20 contract workers, then you have to again take a registration certificate under the Contract Labor Act. So apart from registration under Factories Act, you have to have a registration certificate under the Contract Labor Act also if you have more than 20 contract workers, 20 or more. Likewise, ESI will become applicable, PF Act will become applicable. Then you have to get the registration done under these legislations also. Of course, as far as ESI and PF are concerned, now it is coming online, so process is being simplified, but yet you have to ensure that it is registered. And while constructing the factory, now one more legislation is introduced, which is Building and Other Construction Workers Act. If you are constructing the factory on your own without entrusting the construction work to a contractor, then you are supposed to take a registration under that legislation also, BOCW, shortly called as Building and Other Construction Workers Act. Suppose if that work is entrusted to a contractor, then the contractor is considered as employer, he is supposed to take the registration. And one other act is the Interstate Migrant Workman Act. If there are contract workers coming from other states, if you have 5 or more such workmen, those people will be considered as interstate migrant workmen. Again, you have to get a registration under this act, apart from all these registrations. So registration is the foremost activity, basic activity. When you set up a factory or even shops and establishment, for commercial establishment in Tamil Nadu, you need not get any registration done. But you have to submit a form called Form S before you start your operations. But in all the other states, you have to register under the respective states Shops and Establishments Act. Again, the validity of the registration certificate will differ from one state to another state. Right, the timeline within which you are supposed to make application for the registration, that will also differ, and you may have to periodically renew it. Forming committees. So in a factory, if there are 250 or more workers, then the occupier is supposed to have a canteen, in which case you may have to have a canteen management committee separately. Likewise, if there are more than 250 workers, again you have to have a safety committee. And if there are more than 1,000 workers, one safety officer must be appointed separately, exclusively. So canteen committee is there, safety committee is there, and one other committee is prohibition of sexual harassment committee. You have to form a committee for that. It is a latest law which is coming up. You have to form a committee particularly for the welfare of the women workers employed in that factory. And works committee. If that particular industry has more than 100 workers,